The Supreme Court this morning issued a ruling on one of the two big cases that it's been holding on to, voted on the Voting Rights Act of 1965, ruled that parts of it are unconstitutional. Big blow, a landmark of the civil rights era legislation. To talk about that run right now, I'm joined by Ashby Jones on set, and we also have Jess Braven down at the Supreme Court. Jess, tell us exactly what the court said this morning.
Under the Voting Rights Act of 1965, areas that have historically discriminated against minority voters are subject to special oversight by the federal government. They have to get approval in advance before changing their voting rules. Today, the Supreme Court struck down the formula the government uses for determining which areas are subject to this special oversight, and that has the effect of basically ending that special oversight because Congress will have to reenact a new formula, something that seems very unlikely given the way the Congress is currently divided.
And then, Ashby, I want to bring you in immediately on this. I mean,
Sure.
You're a lawyer, you have a background on all this. How significant is this? How much of this is now washed away?
Well, I think it's very significant. I mean, as just indicated, I mean, they only struck down Section 4, one section in the Voting Rights Act, but it effectively neuters the entire Voting Rights Act, which was, as you mentioned in your opening, a linchpin, really a key of civil rights legislation back in the 1960s, giving a lot of disenfranchised black voters, minority voters, the better chance to vote. Right now, what will have to happen is Congress will have to go back and fix Section 4, this formula for deciding which states should be covered by the Voting Rights Act. Congress has been very reluctant to fix the Voting Rights Act in the past. The Supreme Court has sort of hinted that it should in previous decisions, and it hasn't. So, as Jess indicated, I think it probably means the end of the Voting Rights Act as we know it for now.
Wow. Hey, Jess, the ruling was a 5-4 verdict. That wasn't a surprise, was it? I mean, that was pretty much as expected.
Well, yes. I mean, this was one of the flashpoints that really divides this court along its ideological axis. You had Chief Justice Roberts and four fellow conservatives, including some veterans of the Reagan administration who had fought to minimize the Voting Rights Act when they were in the executive branch, them striking down this coverage formula, and the four more liberal members of the court vigorously disputing it with a dissent read by the senior justice in dissent, Justice Ruth Bader Ginsburg, and really focusing on the origin of, as she said, the question here is who should decide. Should it be the court or should it be Congress which decides how to implement the powers of the 14th and 15th Amendments, which deal with voting rights and minority rights? I think we should say that the Voting Rights Act, the substantive provisions, in other words, it still remains a violation of federal law to impose discriminatory methods to disenfranchise voters and so forth. What has changed today is that the police power the federal government has had to prevent those kinds of changes before they happen has been eliminated. The reason that Congress in 1965 and then implemented this formula and then renewed it periodically, most recently in 2006, was because many of these jurisdictions, as soon as they would have a voting procedure that was thrown out for suppressing minority votes, they would cook up another one. If a voting test was thrown out, they'd come up with, they'd move the polling sites, or they would do all kinds of things to suppress minority votes. Having found that repeatedly was the practice, primarily in the South in those days, the Congress said, well, that's enough. From now on, if you are a jurisdiction that previously did these things, you need to get approval before you make changes. The Supreme Court said today that times have changed, that there is no longer evidence justifying that formula, that places that once were notorious for their racially discriminatory practices no longer are. Maybe some other parts of the country are actually more suppressive of minority votes, and therefore this coverage formula is no longer relevant. That was the view of the majority.
Hey, Jess, this is Ashby. So do you think that this, thanks for the clarification on which parts of the Act are actually likely to go away. Do you think that there's a chance that Congress could wade back into this and sort of resuscitate Section 4 and Section 5, this part of the Voting Rights Act that provides federal oversight over certain jurisdictions, or is that unlikely to happen?
I think it's very unlikely given the current composition of Congress because this is really a question, as framed by the majority and by the minority on the court, of federal versus state power. The majority on the court views this pre-clearance provision, this states and localities having to get permission from Washington before they change their voting procedures, as a great imposition on state autonomy and state sovereignty, and can only be justified by the most extraordinary misconduct by the state. The minority in the court says, no, we disagree. The Civil War amendments, particularly the 14th and 15th Amendments, which give Congress power to prevent racial discrimination, and specifically in voting under the 15th Amendment, those make it up to Congress. But I don't think that particularly the House of Representatives, where the Republican majority is very suspicious of federal power, would be inclined to give the Obama administration, the current administration that's in power, or allow them to continue to have oversight of voting procedures in what primarily are Republican-leaning states.
All right, Jess Braven, Ashby Jones, thank you very much, both of you.